So here, this one came in, again, from our Reddit community, and it's about someone who's inventing on the job, which is a really important category. So what if on the job I make something and the company just decides to patent it? They're just writing the patent now and it should publish in November. What happens if I leave the firm, okay, in September before it publishes? Do I still get my name on the patent? Great question. Well, the answer to that question is yes. As the inventor, it is actually legally required for your name to be listed on the patent. Usually, and I'll say 99% of the time, especially if you're working for a larger company, when you sign on to become an employee, as part of that contract you sign, you've got the obligation to assign, right? To give your rights to the company if what you created was on the job. And it sounds like in this case, that's what it was. You're working, maybe your job as an engineer or a designer. You come up with a new design, a new invention in furtherance of what you're doing for your position. That's going to belong to the company. So traditionally, the inventors do have rights to fully exploit, right? Make, use, sell, import those products. But by nature of that employment agreement, you are giving up those rights to the employer. So take a look. Maybe there's a chance that there's not that clause in your employment agreement, and you might be able to have some rights. But odds are it's going to belong to the company. But your name will be on it, which is awesome. And I think that'll be there. So you can definitely use that as a avenue for resume building, perhaps, to showcase something that's been published that you worked hard on. So there's additional benefit to having that, even if you don't have the actual rights to exploit or make money from it. You've got that published document that's irrefutable, that you were the one that came up with this, maybe one of a few others that came up with this concept.